Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're going to be talking about how and when our fundamental charter rights can be overridden. Our Charter of Rights and Freedoms guarantees our fundamental rights. Rights like freedom of expression, freedom of religion, freedom from arbitrary arrest or unreasonable search, and our right to equal protection under the law. But did you know that politicians in power can override some of these fundamental rights for 5 years at a time? They do this by invoking another part of our Constitution, Section 33, which is also sometimes called the Notwithstanding Clause or sometimes the Override Clause. And it's a unique feature of our Constitution. It applies to some parts of the Charter, but not to others. For example, it can't be used to override voting rights and democratic rights, mobility rights, or language rights. Now, Ontario's Premier Doug Ford has recently invoked Section 33 to pass legislation that limits the ability of third-party advertisers to run political ads. But Premier Ford is only the most recent politician to invoke Section 33. Today, we're going to be joined by 3 legal and political experts to talk about when Section 33 is used, how it's used, and its role in our Constitution and democracy. We're joined first by Professor Nelson Wiseman from the University of Toronto and by Kara Zwiebel from the Canadian Civil Liberties Association. We'll then be joined by Peter Bureau, a Toronto lawyer and founder of Section 1, a democracy and civics education organization. Mr. Wiseman, Ms. Zwiebel, thank you so much for joining me today. Now, Mr. Wiseman, Professor Wiseman, I gave a bit of an introduction about Section 33 and how it's used. What can you add to that explanation? And can you give our viewers a walk through how Section 33 gets invoked, why and when, and what are its limits?
Well, let's remember Section 33 itself is part of the Charter of Rights and Freedoms. And it was inserted into the Constitution in 1981, almost 40 years ago. And it was a condition of the rest of the Constitution moving ahead, which included the rest of the Charter and some other elements, such as the ability for Canadians now to change their own Constitution without appealing to the Parliament of the United Kingdom, which was the case before. So, Section 33 was something demanded by some provinces, specifically Saskatchewan, which was ruled at the time by an NDP government, and Alberta, which was governed at the time by Conservatives. So you had 2 governments that were quite ideologically different, and they both wanted the Section 33. Manitoba also. In fact, Manitoba was opposed to even having a Charter of Rights because it thought that it took away from the rights of its legislature.
So as I understand, it was a bit of a compromise in order to get the Charter passed. Now, Ms. Zwiebel, as I mentioned in the introduction, Doug Ford has recently invoked Section 33 in this case related to political advertising. What can you tell me about the background of that particular case?
A few years ago, actually, under the former Ontario Liberal government, legislation was introduced to limit third-party advertising in the 6 months prior to an election. So there's been some restrictions that happen during the election period once the election writ is dropped, but there was new legislation that extended this to a pre-election period and sort of capped the amount that could be spent. The Ford government introduced legislation that would have extended that pre-writ period. So it meant that for a full year before the election was called, third parties were constrained in what they could do. And it's important to understand that it's not just advertising. It's not just advertising that might be promoting a particular candidate. The definition includes issue-based advertising, so issues that might be associated with a candidate.
And one of the things I think there's a misconception with this case is that it's just about unions. This is any third-party advertising. It's not just a particular type. Is that correct?
That's true. Yes. So unions have been the groups that have made the most use of this in Ontario, but this applies to any group or even individuals that might want to get out there and do some issue-based sort of campaigning.
Well, we've got to go to a commercial break, but when I come back, Professor Wiseman, I want to ask you about the political consequences that politicians bear when they invoke Section 33. We will be right back with these commercial messages. Welcome back to Canadian Justice, where we're talking about Section 33, the notwithstanding clause in our Constitution, and when it's been used. Now, Professor Wiseman, this situation on Ontario with this political advertising law, it looks like, to me, an especially political use of Section 33. Is that usually the case, that it's used in these very political situations? And it also seems to have created a really significant public backlash. How common is it for there to be such a negative public reaction to the use of Section 33?
Well, actually, my impression is that the backlash isn't nearly what it was a couple of years ago when the Ford government threatened to use Section 33 during the municipal election campaign. And I thought there was a much bigger storm at that time. I'm actually surprised how little blowback there's been to this decision, because this is the first time that Section 33 has been used in the context of an election, of voting. And you mentioned democratic rights at the beginning, and that's one of the rights that can't be overridden using the notwithstanding clause. And so that could still end up being tested in court, whether our democratic right to vote somehow has been abridged by a limitation on our being informed about a vote. So every use of the notwithstanding clause is political in the sense that the government introduces it. And the government, of course, is a political actor. But some uses of it have been much more controversial than others. Quebec's use of it has been very controversial in English Canada. There have been many uses of the notwithstanding clause that haven't even been reported in the media. It was used by 2001. It had been used around 15 to 20 times in various provinces, but they were on very small technical matters, and they didn't stir up any politics. In fact, the cases weren't even reported. But in this case, in these kinds of cases, they're much more high profile because they are political. Our elections are political. Now, if I could just say one other thing, what we've noticed is that the notwithstanding clause has been used by a number of provinces in various contexts, some very controversial, some less so. But the federal government and the federal parliament has never invoked Section 33. So I see a distinction that's already arisen where I think it's highly unlikely that the federal parliament will ever use Section 33. And now it's more likely than ever that a number of provinces will increasingly use Section 33. And Quebec has had no compunction about using it from day one. Starting in 1982, when the charter came into force, they applied it to all legislation.
Now, Kara, how do you respond to Professor Wiseman's comment? Do you think that there's an increasing frequency? I mean, your organization was also involved in the Quebec case where Section 33 was invoked to limit the use of religious symbols by public sector employees. Are you concerned about sort of the normalization of the use of Section 33?
Yeah, Quebec, I think, is a unique situation, partly because they weren't really on board with the charter to begin with, and so as a matter of principle, they said we're invoking the notwithstanding clause. They did it proactively. It was typically not in response to a court striking a law down. It was just to say we're not subject to this. We didn't agree to it. In Ontario, obviously, this is the first time that we've had the clause being invoked. I agree. It was very controversial when the premier suggested he might use it in the context of the municipal election. And I am concerned, especially with how quickly this gets sort of pulled out. That there's something that a court might say they don't agree with, and a politician decides, well, we'll just invoke the notwithstanding clause. I would hope that there should be some recognition that this is something to really deliberate over and take seriously. In the case in Ontario, the election law was found to be unconstitutional by a Superior Court judge. The government didn't appeal that decision. They just decided to invoke the notwithstanding clause.
And you are pursuing that case still and challenging the use of Section 33 in that case. My understanding is because it's being construed as a democratic voting rights issue rather than an expression issue. That's all the time we have. Thank you both so much for coming on and for sharing your insights with our viewers.
Thank you.
Thank you.
Welcome back to Canadian Justice, where we're talking about the Limitations Clause, Section 33. I'm joined now by lawyer Peter Biro, founder of Section 1, a democracy and civics education and advocacy organization, and editor of the book Constitutional Democracy Under Stress. Mr. Biro, thanks so much for joining us. Now, you've written a column recently in the National Post that says Section 33 has no place in a liberal democracy. It ought to be repealed. Can you tell me why you think Section 33 should be removed from the Constitution?
Certainly. And first of all, thank you so much for having me on your program, Christine. I appreciate the opportunity to talk about this important matter, public policy and law. The difference really between a liberal democracy and what I properly call actually a liberal constitutional democracy, on the one hand, and any other kind of democracy, is that in a liberal democracy, legislatures make the laws, but the courts, when we turn and we defer to the expertise and the judgment of the courts to ensure compliance with those laws, when those laws are impugned, when someone challenges the validity of them on any ground. And when it comes to constitutional issues, it's important to remember that the Constitution is the supreme law of the land. Section 52 of our Constitution Act actually says that. So the idea in a liberal constitutional democracy is that the courts adjudicate on questions of whether or not legislatures are out of bounds when they make a law. Courts don't adjudicate on the wisdom of legislatures, on the purpose of laws, on the soundness of laws, on the public policy questions, but they do adjudicate those questions that involve their own expertise, which is to determine whether a law actually infringes, in this case, the supreme law of the land, which happens to include our Charter of Rights and Freedoms. So you can't have legislatures be checks on themselves when it comes to those particular matters. So the problem with Section 33, of course, is that it allows the legislature to be both the enactor of the law, the maker of public policy, and the adjudicator. And in fact, there's not even an adjudication required under Section 33. All that a legislature has to do is to say that it doesn't want to submit its law to oversight or scrutiny by a court to determine, in fact, whether there is an infringement of a law.
Yeah, so Peter,
I
think that's one of the things that you've pointed out as one of your big criticisms is there are very few limits on when Section 33 can be used. But can you explain to our viewers what those limits are and how insufficient they are?
Well, there really aren't limits. There are formal conditions under which that have to be met, and that has to do with the length of time that the invocation of the notwithstanding clause applies. And it also has to do with the specific charter rights and freedoms in question. And I won't get into section numbers because that will just confuse the audience. The important thing to know, though, is that those limits, as the law now stand, have nothing to do with questions about whether it would be a wise use of the notwithstanding clause, of whether it would be overreach, about whether the infringement of a given right or freedom in question is egregious or, semi-sensible or at least understandable. None of that is required. There's simply no requirement to be accountable to civil society broadly when a legislature decides to invoke Section 33,
Now,
which is
Peter,
completely different
so
than
one of
when
the
Section 1 is used under the Charter. And we can talk about that if you like.
so you have advocated for repeal, but how would
Yes.
repeal work practically? How difficult would that be to achieve, under the amending formula of our Constitution, but also politically? Why would politicians want to give up one of the most powerful tools in their toolbox?
Yeah, well, many of them wouldn't. So your question is a good one, and it's probably the right one, because a lot of people who've kind of looked at the history of charter jurisprudence since 1982, when the charter came into effect, or when actually came into effect most fully in 1985, but it was enacted in 82. Recognize that the notwithstanding clause is a problem. Even Pierre Trudeau, who presided over the entire exercise at the time, patriation and the charter, didn't like the notwithstanding clause. But the fact of the matter is that amending a constitution is a big deal. It's very difficult. It requires political leadership. It may take a couple of generations of leadership and advocacy to get it done. And then, of course, there are the formalities of the amending formula itself.
Now, why don't we get
into those technicalities?
Yeah, let's take a commercial break,
easy.
Peter, and then we'll continue this conversation after. Welcome back to Canadian Justice, where we're talking about the Notwithstanding Clause, Section 33, with lawyer Peter Biro. Now, Mr. Biro, I want to put to you some of the arguments that have been made in favor of Section 33 because it does have its defenders. And one of those arguments is that Section 33 reflects a political culture and history that sought to correct the democratic dangers of having disagreements about rights settled exclusively by the courts. How do you respond to that concern?
Well, legislatures should be dealing with disagreements over policy, and it's courts that need to deal with disagreements over rights and rights infringements. That's how I would respond. And I think I would point to the danger of, a tendency towards or a reversion or reliance on majoritarianism, on the idea that the people are always right. We know from history, and we don't have time to get into it now, but very dark history, both in Canada and on the European continent and elsewhere, that majorities can sometimes agree to do terrible, terrible things that we know in the moment, and certainly, with 2020 hindsight, are just absolutely unacceptable in every possible way. Surely you don't want to give majorities the right to determine whether their judgment is wise and whether a rights infringement is justified. The courts have to have that. In a liberal constitutional democracy, we have Section 1 of the Charter that actually allows legislatures to come forward and say, well, we acknowledge that there may be a rights infringement here. Here's how we propose to justify that. And there is a test that is met that has to be passed. And if it's passed, what it effectively does is it actually validates the very rights that are being infringed by, first of all, acknowledging the infringement, and secondly, advancing a policy that may restrict or limit a right in a manner that is respectful of the broader regime or scheme of rights and freedoms and of civil liberties generally. That's how it should be done in a liberal democracy.
Yeah, so for our viewers who don't know, Section 1 is another part of our Constitution that is called the Limitations Clause. It allows courts to decide if a limit to a right is justified, and there's a test for when a limit is justified or not. Now, Peter, another argument I hear in favor of Section 33 is that there are consequences for politicians who over-rely on it. These are political consequences that keep them in check. So how do you respond to that?
I say not necessarily at all. Majorities may, in fact, be delighted to see rights continue to be infringed. Look at the history of language, the French language law, Bill 101 in Quebec. And I'm not saying that there isn't a strong and compelling political argument for that kind of a language law. In my submission, actually, it could be introduced in a way that would satisfy the requirements of Section 1 of the Charter. But the bottom line is we shouldn't count on electorates penalizing or sanctioning political leaders when they inopportunely or injudiciously resort to Section 33 to suspend the operation of critical sections of the charter.
So, Peter, we've got about 1 minute. One of the cases people frequently cite as a good use of Section 33 is this case in Saskatchewan where it was used to protect funding for Catholic schools, public funding for Catholic schools. What's your response to that case?
Well, ultimately, it wasn't used for that because the Court of Appeal actually determined that there was no need to go that far because it determined that the legislation in question didn't actually result in a rights infringement. So the trial judge was overruled, and the Supreme Court in that particular case declined to even hear the appeal from the Saskatchewan Court of Appeal. So I'm not, one can understand the policy inclination to resort to it in that case, but I see no need to have done so. I think if there was an argument to be made, resort could have been made to the Section 1 test.
Peter, that's all the time we have. Thank you so much for joining us.
Thank you.
We've heard today about the history of Canada's Notwithstanding clause, its role in our Constitution, the times it's been invoked, and the argument for repealing it. Now, the use of the Notwithstanding clause by Doug Ford recently and its use by Quebec's Premier Legault are both terrible, in my opinion. These politicians use Section 33 to pass legislation that violates important rights, and they did it to gain political advantage. But also, in my view, Section 33 is part of our Constitution and was available in those situations. Now, these premiers should face political consequences, but should Section 33 also be repealed? Or was it part of the compromise that was made to get the charter passed? You be the judge. I'm Christine Van Gyn, and remember, a freer Canada starts with you.